party or our politics wants that. Now, we've gone through the highlights of the precedent, and I think it's important that you know, as Lead Manager Raskin mentioned, that scholars overwhelmingly who have reviewed this same precedent have all come to the same conclusion, that the Senate must hear this case. Let's go through just a few short examples. To start, all of us, I know, are familiar with the Federalist Society. Some of you may know Stephen Calabrese personally. He's the co-founder of the Federalist Society. He actually was the chairman of the board in 2019. He was the first president of the Yale Federalist Society chapter board, a position that I understand Senator Hawley later held. Here is what Mr. Calabrese has to say. On January 21st, he issued a public letter, stating, "Our carefully considered views of the law lead all of us to agree that the Constitution permits the impeachment, conviction, and disqualification of former officers, including presidents." And by the way, he's not the only one. As Lead Manager Raskin said, President Reagan's former Solicitor General, among many others. Another prominent conservative scholar, known to many of you, again personally, is former 10th Circuit Court of Appeals judge, my circuit, Judge Michael McConnell. He was nominated by President George W. Bush. He was confirmed by this body unanimously. Senator Hatch, many of you served with, he had this to say about Judge McConnell, that he's an honest man. He calls it as he sees it, and he's beholden to no one and no group. Well, what does Judge McConnell have to say about the question that you're debating this afternoon? He said the following: "Given the impeachment of Mr. Trump was legitimate, the text makes clear that the Senate has power to try that impeachment." You heard Lead Manager Raskin mention another lawyer, Chuck Cooper. He's a prominent conservative lawyer here in Washington, has represented former Attorney General Jeff Sessions, House Minority Leader Kevin McCarthy. He issued an editorial just 2 days ago, very powerful, observing that scholarship in this question has matured substantially, and that ultimately the arguments that President Trump is championing are beset by serious weaknesses. Finally, we've gone through a lot of scholars. I'll finish on this one. There's another scholar that I know some of you know, and some of you have actually spoken with recently. Up until just a few weeks ago, he was a recognized champion of the view that the Constitution authorizes the impeachment of former officials, and that is Professor Jonathan Turley. Let me show you what I mean. These are his words. First, in a very detailed study, thorough study, he explained that, quote, "The resignation from office does not prevent trial on articles of impeachment." That's Professor Turley's words. Same piece, he celebrated the Belknap trial. He described it as a corrective measure that helped the system regain legitimacy. He wrote another article. He's written several on this topic. This one is actually, it's a 146-page study, very detailed. And in that study, he said, quote, that the decision in Belknap was correct in its view that impeachment historically had extended to former officials, such as Warren Hastings, who you heard Lead Manager Raskin describe. In fact, as you can see, Professor Turley argued that the House could have impeached and the Senate could have tried Richard Nixon after he resigned. His quote on this, very telling, quote, "Future presidents could not assume that mere resignation would avoid a trial of their conduct in the United States Senate." Finally, last quote from Professor Turley, that "no man in no circumstance can escape the account which he owes to the laws of his country." Not my words, not Lead Manager Raskin's words, Professor Jonathan Turley's words. I agree with him, because he's exactly right. Now, a question one might reasonably ask after going through all those quotes from such noted jurists and scholars is, why is there such agreement on this topic? Well, the reason's pretty simple. Because it's what the Constitution says. I want to walk you through 3 provisions of the Constitution that make clear that the Senate must try this case. First, let's start with what the Constitution says about Congress's power in Article 1. You heard Lead Manager Raskin make this point, but it's worth underscoring. Article 1, Section 2 gives the House sole power of impeachment. Article 1, Section 3 gives the Senate the sole power to try all impeachments. Now, based on President Trump's argument, one would think that language includes caveats, exceptions, but it doesn't. It doesn't say impeachment of current civil officers. It doesn't say impeachment of those still in office. The framers didn't mince words. They provided express, absolute, unqualified grants of jurisdictional power to the House to impeach and to the Senate to try all impeachments. Not some, all. Former Judge McConnell, judge that we talked about earlier, he provides a very effective textual analysis of this provision. You can see it up here on the slide. I'll just give you the highlight. He says, and I'll quote, this is Judge McConnell, "Given that the impeachment of Mr. Trump was legitimate, the text makes clear that the Senate has power to try that impeachment." Now again, here is what is pretty interesting, me at least. When we presented this argument in our trial brief, which we filed over a week ago, we laid it out, again, step by step, so that you could consider it, and so that opposing counsel could consider it as well. We received President Trump's response yesterday, and the trial brief offers no rebuttal to this point. None. And in fairness, I can't think of any convincing response. I mean, the Constitution is just exceptionally clear on this point. Now, perhaps they will have something to say today about it, but they did not yesterday. There's another provision worth mentioning here, because there's been a lot of confusion about it, and I'm going to try to clear this up. It's the provision on removal and disqualification. Now, we all know the Senate imposes a judgment only when it convicts. Up on the screen, you'll see Article 1, Section 3, Clause 7. So with that in mind, the language says that the Senate convicts, the judgment shall not extend further than removal and disqualification. That's it. The meaning is clear. The Senate has the power to impose removal, which only applies to current officials, and separately, it has the power to impose disqualification, which obviously applies to both current and former officers, but it doesn't have the power to go any further than that. Now, as I understand President Trump's argument, they believe that this language somehow says that disqualification can only follow removal of a current officer. But it doesn't. That interpretation essentially rewrites the Constitution. It adds words that aren't there. I mean, after all, the Constitution does not say removal from office and then disqualification. It doesn't say removal from office followed by disqualification. It simply says the Senate can't do more than two possible sentences: removal and disqualification. And this, by the way, is not the first time that this direct question has been debated in this chamber. 146 years ago, during the Belknap trial, Senator George Edmunds of Vermont, he's one of the most prestigious Republican senators of his time. He sat right where Senator Grassley sits today. He zeroed in on this exact point during the Belknap trial. This is his quote: "A prohibition against doing more than two things cannot be turned into a command to do both or neither." And just imagine the consequences of such an absurd interpretation of the Constitution. I mean, if President Trump were right about that language, then officials could commit the most extraordinary, destructive offenses against the American people, high crimes and misdemeanors. They'd have total control over whether they can ever be impeached, and if they are, whether the Senate can try the case. If they want to escape any public inquiry into their misconduct or the risk of disqualification from future office, and it's pretty simple. They could just resign 1 minute before the House impeaches, or even 1 minute before the Senate trial, or they could resign during the Senate trial if it's not looking so well. That would effectively erase disqualification from the Constitution. It would put wrongdoers in charge of whether the Senate can try. Third and final reason why President Trump must stand trial. Provision of Article 1 of the Constitution. You'll see here on the screen that the Constitution twice describes the accused in an impeachment trial. Here's what I want you to focus on. The interesting thing is, notice the words. It refers to a person and a party being impeached. Now again, we know that the framers gave a lot of thought to the words that they chose. They even had a style committee during the Constitutional Convention. They could have written civil officers here. I mean, they did that elsewhere in the Constitution. That would have ultimately limited impeachment trials to current officials. But instead, they used broader language to describe who could be tried by the United States Senate. So who could be put on trial for impeachment other than civil officers? Who else could a person or a party be? Well, really, there's only one possible answer: former officers. And again, that actually might explain why, during the Belknap trial, Senator Thomas Bayard of Delaware, he later became the Secretary of State for the United States. He sat right where Senator Carper is sitting now. He found this point so compelling that he felt compelled to speak out on it. And during the trial, he concluded that the Constitution must allow the impeachment and trial of people and parties who are not civil officers. And the only group that could possibly encompass was former officials